all present. Mr. Gray is back in the courtroom. The community has great interest in the case, which is certainly understandable. So I'm going to give a detailed explanation here. What you, the families, are going through, what the community is going through is it's undeniable pain, and I understand that. The emotions that the community feels are overwhelming, I'm sure. I don't know that you can, but understand that the law does not permit me to be emotional, and I'm constrained by the law. Now, a statement was made, again, understandably, that I'm here to seek justice. Understand that at a bond hearing is not where justice is dispensed. Ultimate justice, in whatever form that takes, comes later through a jury trial. The law at a bond hearing is that the accused is presumed innocent. Now, that's despite whatever's been said about the case through the media or through a first appearance hearing or through any other avenue. As we sit here, the law presumes that Mr. Gray is innocent. No facts have been established in this case yet. Again, despite anything that's been said before. Those facts will come through other hearings, they'll come through a jury trial. Now, the legislature in the Supreme Court, and it's been referenced, have laid out factors that constrain courts in determining bond. One is a risk to flee. Now, what that normally looks like is someone has prior failing to appear at court convictions, or someone has in fact fled charges before. That is not what we have here. Another factor is the danger to the community. Now, if we assume guilt, that danger is obvious. But I'm not allowed to do that. He's presumed innocent as we sit here. There is no independent evidence that he's a danger to the community. There's no recordings of him in jail saying he's going to do this when he gets out. There's no prior crimes where he has done something else that puts those in the community in harm's way, which leads into the next factor, the risk of committing a felony while on trial. I think it was said that he's 54 years old, 50 some odd years old, has no prior felony convictions, has a 1998 or 99 marijuana misdemeanor charge. The fourth factor is intimidating witnesses. Generally, again, there's evidence of that. He's making jail phone calls, trying to get someone to change their story. He's making statements about what he's going to do so that this witness can't testify. We do not have that in this case. Now, the legislature nor the Supreme Court have said that one of the factors for determining bond is the impact on the victims. It's not one of the factors that I'm supposed to consider in granting bond. Now, having said that, the foremost consideration in determining bond is whether or not the accused will appear to stand for trial. And I do have grave concerns here. This is not the typical case. In an ordinary case, a defendant's given a bond, he makes the bond, he returns to the community, essentially unnoticed by anyone. That's not what would happen here. This case is an open sore. It's a wound that continues to hurt the community. While in court, Mr. Gray is presumed innocent, in the court of public opinion, he bears a scarlet letter. I don't believe that there's any way that Mr. Gray could return to this community as a as an accused often does when granted a bond. Now, his ties to this community are minimal. The state has pointed out that he has moved and lived in 6 or 7 different places over a relatively short period of time. I am allowed to consider the charges and the punishment that he faces if convicted. And were he to be convicted of these 29 charges, he faces the prospect of the rest of his life being in prison. And that is something I'm allowed to consider. So weighing all of these considerations, I believe that it is, one, required to give a bond, but 2, given the extraordinary nature of the case and the other factors, that it needs to be a high bond. I'm going to grant a $500,000 bond, which is necessary to ensure that Mr. Gray appears at trial. I'm going to require 10% of that to be a cash bond. As a condition of bond, he's to have no contact with any of the witnesses whatsoever. I'll prepare a order.
Thank you.
All right, Zach, do we need to take up anything else? I know that we had a conference call, but this case is not going to be, it's continued off of this trial calendar that I'm having court for today. I think the defense indicated you'd be filing motions in the next week or so, is that right?
That's accurate, Judge. Yes, sir.
Okay. After those motions are received, reviewed by the state, then we'll discuss a scheduling order.
Thank you. All right, be excused.
Yes, sir. Thank you.